In this episode, we will be discussing California landlord may not demand rent for uninhabitable property. The California Civil Code, Chapter 2, Section 1942.4 states that a landlord of a dwelling may not demand rent, collect rent, issue a notice of a rent increase, or issue a 3-day notice to pay rent or quit if all of the following conditions exist prior to the landlord's demand or notice. Government notices and pre-existing conditions. The dwelling substantially lacks any of the affirmative standard characteristics listed in our video. California landlord building must be fit for occupancy, or it violates the health and safety code and conditions exist that endanger the life, limb, health, property, safety, or welfare of the public or the occupants. A public officer or employee who is responsible for the enforcement of any housing law after inspecting the premises has notified the landlord or the landlord's agent in writing of his or her obligations to abate the nuisance or repair the substandard conditions. The conditions have existed and have not been abated 35 days beyond the date of service of the housing law notice, and the delay is without good cause. For purposes of this subsection, service shall be complete at the time of deposit in the United States mail. And finally, the conditions were not caused by an act or omission of the tenant or lessee. Damages for landlord noncompliance. A landlord who violates this section is liable to the tenant for the actual damages sustained by the tenant and special damages of not less than $100 and not more than $5,000. It is important to note the prevailing party shall also be entitled to reasonable attorney's fees and costs in an amount fixed by the court. Court-ordered repairs. Any court that awards damages may also order the landlord to abate any nuisance at the rental dwelling and to repair any substandard conditions which significantly or materially affect the health or safety of the occupants and are uncorrected. If the court orders repairs or corrections, or both, the court's jurisdiction continues over the matter for the purpose of ensuring compliance. It is important to note, any action under this section may be maintained in small claims court if the claim does not exceed the jurisdictional limit of that court. For additional laws and articles, visit AmericanLandlord.com.